So hello again, we'll start over. It's been a while since I've been on television, so this is relatively new. Okay, so here's what we're gonna do. We're going to draft for all of you in real time an incorporation advice memo. And the idea is not just to give you advice, but to reflect some on what we've heard from the Delaware judges and also what's been happening in Delaware in the last year. And we are going to do so talking about a number of issues, but not live issues that we have in front of those judges. So we've kind of agreed to some ground rules. We aren't going to reopen wounds related to recent events, and our goal is to be constructive for anyone who's thinking about Delaware versus the rest of the world. All right. So if you're actively thinking about this decision, our goal is to actually write you a memo right now. When I say it'll either be really easy or really hard for me, it's because likely what I'll be doing is just saying the first names of each of these four distinguished people as they start to mix it up. And we did agree on an order, so I will begin by asking Elena Norman, a partner at Young Conaway in Delaware, to set the stage as the only currently practicing Delaware lawyer on the panel. And Elena can talk about the positives of Delaware and give us a framework for our memo and the advice that we're going to give you. Rick Horvath, a partner at Deckert, will be next. He's a reformed litigator, he says, who advises on an array of corporate governance matters, including conflicts, special committees, shareholder activism, and board processes, and he will address client concerns about certainty and predictability and compare and contrast some other jurisdictions, some issues that were just raised. Then Yaron from Bernstein will give the institutional shareholder perspective and discuss the high quality of many of the Delaware cases we just talked about, but the high quality of cases in Delaware in general with some examples. And also, I hope, some big picture thoughts from his own distinguished scholarship, including recent thinking about history and cases over time. And then Ed will clean up, a partner at Gibson Dunn, will note, I hope, that the three of you are litigators, and he will give us the transactional perspective, including harm from some recent Delaware rulings that he'll tell us about, and he'll talk some about long-term planning. Ed has a window into how deal clients now are thinking about Delaware versus other states. Okay, with a somewhat disruptive beginning there, I apologize for that, but that sets the stage for us, I hope. And now I will just maybe periodically say your first names, maybe not, I don't know, but let's start with Elena.
Thank you. Thanks, it's a pleasure to be here, as always. I'm here to make the case that you ought to stay in Delaware. Maybe I'm a little biased, I do practice in Delaware, but practicing there, and practicing in the Court of Chancery primarily, I really have had the opportunity to see firsthand just what a great place it is for corporations and other stakeholders. You know, Exhibit A is the panel you just heard of our three esteemed jurists who are just absolutely excellent, you know, so steeped in the corporate law, how it works, scholarly, serious, flexible, and as hardworking as they come in terms of judges. So I think, you know, as many of you in this room know, the judges on the Court of Chancery hear primarily corporate law cases. They have 12-year terms, so they really have time to dig in. They're appointed by the governor of Delaware after a rigorous vetting process. And they really have the time to dig into the individual equities of individual cases. I think, as Vice Chancellor Glasscock said, equity doesn't do bright line rules very well, and that is why the job of the vice chancellors and the chancellor is perhaps particularly difficult, because each case they really dig into the factual allegations of that case, if it's a motion to dismiss, the evidence of that case, if it's past a motion to dismiss, but they are able to really, I think, create a stable environment where corporate litigants can make sure their case is heard and taken very seriously. There's also a direct appeal to the Delaware Supreme Court. There are other elements that make Delaware a great place as well. The Secretary of State's office makes it easy to incorporate. It's user-friendly and quick. The legislature reviews the Delaware corporate laws every year. I think Nevada touts more predictability because it's only changed every 2 years. But I submit that in considering whether to stay in Delaware or not, the fact that the Delaware legislature reviews the corporate law every year makes it flexible and dynamic and helps make sure it's current and modern. Yes, there are occasional bumps in the road because sometimes it takes time for the law to settle. As I said, law gets made through cumulative decisions. It's very fact-based. And doctrines are not totally locked. They evolve through specific decisions in specific cases, but judgment and equity is a big part of it. And usually I think the courts get it right. And sometimes in emerging issues, it takes a couple of years for the law to settle. We saw that in other doctrinal areas over the years, for example, in the Unical or in Revlon contexts. And so you have to, the courts and sometimes the legislature have to figure out how the rules should evolve over time. Over time, I submit Delaware gets it right, and it's not plaintiff-friendly or defense-friendly. Delaware's interest is being attractive to incorporators, being just and being equitable, and overall, I think it works very well, and it's really, I think in the market for corporations, Delaware will continue to do very well, and as I think you heard on the last panel, there have been times before where there's been sort of chatter about moving out of Delaware and Delaware having lost its preeminence, but I think we feel very confident and very secure in the stability of Delaware corporate law and the courts.
So we have a nice, eloquent preamble to our memo, pro-Delaware, comma, but. Rick.
Yeah, and the but is over the past, I would say even before this year, but the past few years, uncertainty has been creeping into Delaware law, and the challenges of advising boards has increased in terms of being able to give more certain advice. And this is a challenge for directors. Directors, when they serve on boards, are acting in good faith, in my experience. They're trying to do their job the right way. But they do have a sense, and I've had this feedback of, well, if I have a company that has an issue, a serious legal issue, have I just bought a bad lottery ticket where I'm now facing litigation and liability for what happened? Likewise, you have had, greater litigation over doctrines that, when they were developed, such as MFW, where there was a hope that this would lead to greater certainty and less litigation over, say, controller transactions, a sense and a feeling and a concern that really what's happening is there's greater chance for footfall or there's greater chance for second guessing, and you're creating litigation risk in addition to transaction risk. So these are some of the challenges that have been developing in Delaware, and it does create some uncertainty. At the same time, there is uncertainty in other jurisdictions if you're trying to balance this. Nevada and Texas, which are the two major domestic discussions for other incorporation forum, you have untested doctrines in those jurisdictions. You have still developing law. You have, in the case of Texas, a brand new business court. We do not know how it is going to handle these cases. And so that itself is an uncertainty. But the test right now of, when you look at these two jurisdictions between Delaware or another forum, unlike, say, 10 years ago, it's a lot harder today, I think, for me as advising clients to say, Delaware is absolutely certain, you know how it's going to play out in these circumstances, and that you should never under any circumstance consider another jurisdiction when I think you're legitimately seeing companies based on the particular circumstances wanting to consider those other jurisdictions. Case in point for Nevada, if you have a company that has a controller or ambiguous controller where they maybe don't have majority voting power, Nevada might be a more appealing jurisdiction than Delaware at this point, given the doctrines that have developed and the critical eye that's going towards controller transactions.
Okay, Jeroen. Some of this is going to, I know some of what you're going to say is about uncertainty and predictability, so I'd like you to just go, but can you also talk a little bit about what Vice Chancellor Glasscock just said about the common law and kind of how you think about certainty and unpredictability in a common law context? I'd be especially interested in hearing that. But we have,
Sure.
I guess your but and your and, or what's the conjunction?
I represent money, okay? I represent the capital. I'm a shareholder lawyer. I'm a shareholder plaintiff's lawyer, so I bring a lot of the cases that you hear about and that you heard about in the previous panel. But my background, so that you understand where I'm coming from and the lens that I look through when I look at the world, as I'm advising you where to incorporate, is I represent the institutional shareholders that are providing the capital for this company. And within my firm, so that everybody knows, I have 2 jobs, actually 3 jobs. One job is I represent institutional shareholders from Europe in securities litigation, and I'm the head of our corporate governance department, so I do all fiduciary duty litigation around the country. So I'm not just in Delaware, I'm also in other parts of the country. Think about the first energy bribery scandal in Ohio. Think about the Credit Suisse derivative action in New York. Think about the TuSimple case in the Southern District of California. So I can give you a perspective about some of the litigation risks that Rick was talking about. And as you are, you're the hypothetical board, as you are thinking about where to incorporate, one other thing. Blair Connolly's sitting over there. He was my first mentor at Latham & Watkins. He's amazing. No dig on Latham & Watkins. But I was there for a number of years. As you are board members.
As was I.
Yeah, I know, we were there together. So as you're thinking as a board, okay, where are we going to incorporate? What are we going to do? I always like to go back to first principles. And when you think about what a corporation is, it's basically, you go to Burley and Means, Jensen and Mecklin, right? Separation of ownership and control, the theory of the firm, agency costs. And those are critical considerations. Those are driving considerations. And the law mitigates or enhances agency costs. Essentially, the idea is, I provide the money, you guys are going to be overseeing the money. How do I make sure that you're going to act in good faith? And if, preview, you incorporate in Nevada, those agency costs are much higher because there is no real policing of fiduciary duties in Nevada. So the law, in my view, and I would urge to you, is a critical tool to figure out how to police and how to mitigate agency costs. And then we get to the question about uncertainty. And my response to you, all fellow board members, is life is uncertain. I know it's very controversial, but life is uncertain. There is no such thing as certainty when you're thinking about human relationships, when you think about greed, when you think about incentives. And the real question that you board members should ask yourself is, and this is actually kind of a basic question, do I believe that directors and officers and controlling shareholders have a duty to be loyal to the company and all of its shareholders have a duty to act in good faith? Do we want these people to act in good faith? If the answer is yes, I respectfully submit to you, Delaware is the place to be. As you all probably know, 2/3 of public companies are incorporated in Delaware. And for good reason. There's a clear separation of ownership and control. Delaware is very responsive to business concerns. Prior panel, you heard a little bit about the Moelis decision. I know there are a lot of hard feelings, everybody around, but one way to look at what happened there is a legislative response to a business concern, and it was rapid. So rapid that everybody's like, whoa, what just happened here, right? But Delaware is exceedingly responsive to business concerns when they're voiced. There's a well-established network of advisors. Take off your board seat hat. That's all of you, right? And so there's a lot of predictability in that, much more than in many other jurisdictions. And then, of course, we have the expert court with deep experience. You heard Elena talk about that. And let's be clear about this. The Delaware Court of Chancery is very pro-director. The assumption is that directors act in good faith unless you have very, very, very strong evidence to the contrary. I have many cases, some of which Vice Chancellor Glasscock referred to, where there's a director who testifies that the controlling shareholder holds literally a gun to the director's head. Okay, I litigate that for years. End result, he finds no damages, he finds no attorney's fees. I don't know if Vice Chancellor Glasscock is listening. I'm not appealing the attorney's fees decision. It's okay, I trust him, always act in good faith. I may appeal the former decision. But it's very, very pro-director, pro-controller, pro-corporate. Very hard for a plaintiff's lawyer like me to win. You heard about the business judgment rule. But, and this is the critical thing, Delaware does require one thing and one thing only. Directors and officers must act in good faith, must act loyally. And I wanted to quote Guth versus Loft. Elena knows the decision well. It's from 1939. And I'm doing this in part to rebut this idea of uncertainty. This has been the law for almost a century. Corporate officers and directors are not permitted to use their position of trust and confidence to further their private interests. If you agree with that, Delaware is the place to be. I continue the quote. The occasions for the determination of honesty, good faith, and loyal conduct are many and varied, and no hard and fast rule can be formulated. The standard of loyalty is measured by no fixed scale. That is Vice Chancellor Glasscock saying, the common law evolves. We respond to particular situations. Or the way I talk to my kids, so long as there's greed, I will have a job, right? So the idea is, if you act loyally, you're going to be protected. Two things about some other jurisdictions. All right, we heard about Nevada. I had a case in Nevada a couple years ago. You know what happened? The judges are elected, and the judge came around asking for campaign donations from all the litigants in the room. All right, you have certainty there. If you spend a lot more, maybe you get a predictable outcome. Is that really the system that you want to buy into? Really? I don't think so, right? Unless, of course, you start from the premise that you don't want to act in good faith, that you're only out for your own interest and not for the interest of the company and all of its shareholders. But like I said before, there are consequences. When I talk to the European institutional investors that have trillions of dollars under management, they look at these things. They consider, do I want to invest in a company like that? Final thing about other jurisdictions. I love litigating in New York. I go to the commercial division. It's awesome. Why? Defense lawyers don't like to be there. They like to be in federal court. They have the cufflinks. I like a brawl, okay? Every case is a jump ball. Talk about uncertainty. In Texas, you heard about Texas? You know what my first job is going to be when I have my next case in Texas? I look for the best local counsel who preferably has been a judge on the same bench and is the cousin of the judge. Can't lose. Can't lose. And so the idea that, you would trade all this uncertainty about some decisions that some people in this room may not like for jump balls around the country, I would think about it.
Okay, so we have three litigators' perspectives at this point, which is great for our memo. And it's especially great for me because I tell my students that the law is a prediction of what a judge will do. Oliver Wendell Holmes told us this idea. He got on the side of Berkeley's law building, right? He's one of two. And this idea about what a judge will say is inherently unpredictable, but it's also predictable in that you're going to get Oliver Wendell Holmes deciding your case, or you're going to get the chancellor deciding your case. But we have three litigators in the memo now. We have a brief pause for Partnoy to talk about Oliver Wendell Holmes, and now we have the deal lawyer finishing it off.
Well, at least we know where people stand. That's the starting point. And kudos to Berkeley when they were architecting the agenda. What better way to distract from the events of the past week or 2 weeks than to put a panel on whether to stay in Delaware immediately after three of the most preeminent Delaware jurists happen to have given a 45-minute soliloquy on it. So no controversy there. My name's Ed. I am a deal lawyer. I do M&A and I do governance. And I'm out of the Palo Alto office of Gibson Dunn. And what I would say is give kind of an SEC disclaimer, which is this is going to be the comments of one little old corporate country lawyer practicing law down in Palo Alto. It is not on behalf of the firm, and please, to those who might be listening in the back rooms, don't take it against the firm in the future. But I do think there's a reason why people are talking about this. So let's dig into it a little bit. And by the way, there's a reason why people aren't talking. The irony of this is we're sitting in California and nobody's whispered the word California, in part because of the strength of Delaware. And I'm a fan of Delaware. Let's cut to the bottom line up front, which is nobody is assailing a mass exodus from Delaware or a mass incorporation elsewhere. I think what there are reasonable questions as to, one, have the cases of the past year in particular been as narrowly tailored and as suitable as necessary if you're coming from a perspective of less regulation is more, right? We live in a system where there's state law regulation, you've got the listing rules for NYSE or NASDAQ, you've got federal securities laws, they all kind of interplay with each other. But I do think there is a question as to the recent spate of cases. I violently agree with Vice Chancellor Glasscock that narrow rulings are the optimal way to go and not to have excess in terms of what's being covered. What I would also say is I don't impugn the Delaware jurists or the Chancery Court at all. As you saw, you listened to them, incredibly intelligent, eloquent jurists who were spending tough amounts of their lives on these issues. So there's no impugning of motives. But what you have in the past year, whether people want to say it out loud or not, is you have CRISPO, which took lost premium, threw it out the door. You have Tornetta versus Musk, which from a certain vantage point, you had a 70% plus stockholder vote in 2018. You had another 70% plus stockholder vote. And this is the mom vote, not the political mom, but the majority of the minority or the disinterested stockholders voting here. So you're taking out the interested stockholders, and still 70% of the stockholders say we're in favor of this pay package. And that pay package is found to be invalid on entire fairness. You have Moelis, which disrupted well-established norms. Now, grant you, it's one of those law school things where bad facts perhaps make not optimal law. And the Moelis set of restrictions in particular, like if you want to go to the bathroom, you need to go get permission, that kind of flavor of restriction on permissive covenant is extreme, okay? So nobody's going to argue that at some point, what is a board supposed to do under the Moelis context? But was it as narrow as it could have been? And were there parts to Moelis that could have survived and been left standing? And then Microsoft Activision, where if you ask the average college-educated graduate, don't forget the man on the street or the woman on the street, just the average college, what's the difference between substantially complete and essentially complete? Okay? Substantially, essentially, I can't have code words in a document, and if I leave the code words in, even though there's a defined term buyer and a defined term seller, my board approval of my merger agreement's no longer valid? Really? Is that as narrow and as restrained as we could ask for? And I think what you saw was, an immediate, every action has an inverse reaction. Every force has an inverse force, equal and opposite force. And you had the Delaware legislature come down and reverse all of this in the market practice amendments, right? That creates a lot of people scratching their head, because as somebody who was in the trenches for 4, 5, 6, call it March to August, and still to this day, I won't go into specifics, but there's some questions about where are the nuances in those market practice amendments and how is it going to play out. And you heard the jurists say that they're going to be tackling those under common law. So let's not kid ourselves. Nevada, I've been there. Nevada's not a particularly fun place to be. They don't have a dedicated chancery court. They don't have a real long established precedent body of law. California, leave aside, they don't have what even Nevada has in terms of established body of law. Mostly, it takes 3 days to get your certificate or your charter amendment filed, and then it gets bounced back because you had a semicolon where the examiner doesn't think the semicolon goes and makes a reference to some bizarre California statute that has no applicability. So this is a direct plea to the state of California to rethink at the Secretary of State level, do you want to have California corporations? And you're entirely right. If you back out Maryland with the REITs and some hometown favorites spread across the United States, the vast majority, overwhelming majority of companies are in Delaware and will stay in Delaware. It's kind of like getting the proxy voting tabular at the end of the day, and you have a director going, well, I got 95% instead of 90, the person next to me got 96%, why me, right? So we're arguing over very finite amounts. But that's not the central question in my mind. The central question in my mind is, how far do we go in controller stockholder liability opinions? And how broadly do we interfere with corporate actions. And I think there are legitimate policy arguments either way, but when you're looking at a startup, a founder-led startup, and I get that there's money and there's founders and the team and the sweat equity, but when you're representing sweat equity, maybe not today, maybe in 5 years, maybe in 10 years, will folks look around and say, you know what, Texas business courts are going to be equivalent to a chancery competitor. They'll have case law over time. Should we try Texas? Will they be more amenable and less disruptive to, say, throwing out a pay package that's been approved by 70+% of the disinterested stockholders? Those are the things that are crumbling around in my mind when I think about these issues. Not just, can I get my charter back in an hour for $1,000, and not just, has Delaware been the preeminent one over time? It clearly has been. There's no dispute about that.
Okay, you can see how I thought I'll just be able to do my little trick of using people's first names now. Everybody gets that, right? I could just call out some names. I will say, just as an observation to our memo overall at this point, and then we'll do 15 minutes of that we have one clear area of agreement, and maybe only one, which is that the Delaware judges are incredibly astute and a precious resource for all of us. And we all will agree on that, regardless of whether people want to leave or be there, that that's extraordinary, and that they are extraordinary. The second observation I'll make is that academics are entirely missing from this conversation and haven't even made it to a footnote yet, and that we should maybe think about that. And as somebody who publishes empirical work, that maybe we should be skeptical before we drop a footnote in our memo to one of those studies that might not be replicable or reliable. Having said that, your own.
Thanks, Frank. So, full disclosure, Elon Musk, Tesla is one of my cases. So I'm not going to speak too much about it because there are still decisions coming out, and then there's going to be the appeal and all that. So the only thing I will say about that is that it is surprising to me that anyone is surprised about the outcome. And I'll say that again. It's surprising to me that it's surprising to anyone about this outcome. I encourage everybody to read that opinion, okay? So some of you will understand the entire fairness standard. First point to know, the defendants, represented by the extremely good law firm Cravath, Swaine & Moore, said to the chancellor that if there is a misrepresentation in the proxy, she should apply entire fairness. So then don't complain to me that under entire fairness, the standard everybody understands, that you have the burden of proof with respect to procedural and price fairness. You conceded it the moment that we showed that the proxy was false and misleading. And I respect what Ed is saying about, the fact that there were shareholder votes. The first one was pursuant to a false and misleading proxy. So I ask you, does that count? Lying to your shareholders and then turning around and saying, well, I got the vote. I don't think so. Not so complicated, okay? Not so complicated. Don't lie to your shareholders. Should be one of your golden rules, okay? Second thing, then there's this whole issue that you hear now increasingly from the defense bar. It's like, I don't know what a controller is anymore. What am I supposed to do? And the answer is, if you look at the opinion, the chancellor is very, very clear. Elon Musk was not a controller of Tesla for all intents and purposes. He was a controller with respect to the pay package. And you know how we know that? He testified that he negotiated the package with himself. I'm sorry. He's standing on both sides of the transaction. He negotiates it with himself. Is it so far-fetched to say he was a controller with respect to the pay package that he negotiated with himself? Come on. Like, come on, right? So
I thought we weren't talking about cases.
No, I know, but I'm just so...
Except for that one.
But to be fair, that decision came out in January, and so I'm not talking about anything else. But
Elena, let me interrupt for a second.
Yeah.
Elena, since I'll call on you now. Elena, do you have something you'd like to say in response?
No. I was just thinking about an opinion that I'm not going to talk about because it is pending, but one that Blair Conley knows very well.
Twice.
No, would you like to make an observation at this point about anything we've talked about?
No, I was just going to say, I think the case I'm thinking about where a visionary founder was found by Vice Chancellor Glasscock not to be a controller, sort of shows that it is very case specific and there aren't bright line rules. And, my observations, I mean, everything I've heard is, to the point about, I don't think anyone in Delaware is suggesting that Delaware should be the place to incorporate simply because it has been for a long time. As the Chancellor said, the courts and everyone in Delaware is working hard every day to try to maintain the reputation and the standards and the excellence that we've had for years. And I think, maybe, to the point that maybe in 5 or 10 years, there will be another place that is seriously competing for Delaware. I mean, I think maybe not, but let them try and we'll see what they can do. But I'm also skeptical when you hear about Nevada being a place where it's more statutorily based than common law to guide corporations. I'm just skeptical that really works in practice, because cases are always, you have to apply the statutory standards to facts, and I think that ultimately does depend on what the courts find and case-by-case adjudication. So I'm skeptical that just putting things in kind of a statutory framework solves some of the things that we've been talking about.
Ed?
I'm in violent agreement with most of what Elena said, which is, if you have a statutory framework and you have judges who are not having exclusive business jurisdiction like the Chancery Court does, it's like getting a butter knife when you want a surgeon with a scalpel, in my mind. And having lived through some of that in Nevada, I mean, no disrespect to the bench in Nevada, but you're dealing with a system that is architected not to have super deep specialists. I do think there is a question in time, will Texas invest the resources and have the level of volume that they can compete, because they're offering an alternate model. So we'll see. The other thing is, we haven't talked about some of the procedural stuff. This is kind of deal law stuff, but I do think there's a question on 220 and how far does 220 go, and how far does Delaware want 220 go? And I realize that's like pulling a pin on a grenade and lobbing it out. But I think, as you heard in the prior session in terms of Disney and how far you go in producing materials, there's a question as to how much of a retrospective factual exam you undergo for pleading standards in 220 claims.
I'm sure Jeroen and I could have a spirited debate on that question.
Jeroen?
I mean, I do, so 220, I think most people are familiar, right? It's a books and records request. And look, if you think about my firm, we have our own private investigators, we have our own financial analysts, called the SEC with profit motive, okay? So we use 220s. And it's very hard to give you total numbers, but I can tell you the vast majority of potential cases we never bring, because we ask for the 220. There's now a process where essentially automatically you get the board minutes. You need to have a proper purpose. That was what Vice Chancellor Will was talking about. Clearly, that is critically important. You need to have a proper purpose for an investigation. But if you have a proper purpose, you have a reasonable suspicion of wrongdoing, you ask for the 220 documents. And we see so many potential cases. We look at the documents, we close the 220, and we never even bring the case. Now, there is a fair amount of litigation surrounding the 220, but in my practice, I'm not saying that that's true for everybody, but in my practice, the only times that we really have 220 litigations are twofold. One is the company refuses to enter into a standing agreement before the deal closes. So we have to file a placeholder complaint, otherwise we lose standing. So if the company says, yeah, we enter into a standing agreement, we never file that 220 petition. We can still complete our investigation after the deal closes and still wrap up our investigation and move on. But a large number of 220 petitions that we file are just to preserve standing, that are actually never litigated. And then the second thing is, sometimes we get into a fight over the scope. And I want to echo something that one of the judges just said, and I think it was Vice Chancellor Will. Board minutes matter. If you craft your board minutes in a way where it's clear what the discussion was, and it's clear that the discussion was at the board level and there was a wholesome discussion and complete discussions, questions were answered, that kind of stuff, okay, it's the end of it. But if you do a lousy job with your board minutes, now we will have to ask for emails. Now we have to ask for documentation trying to figure out what actually happened. So then we typically have a fight, right? Because people don't want to produce emails. We say we should. We go to the special master. But I would say that that's less than 5% of the cases that we have, because most people actually prepare very good board minutes. And it's, like I said, the vast majority of cases never actually become cases.
Rick?
Touching on the board minutes issue, again, you're getting into you have the general rules you want to follow, but you can also have foot faults, and we've seen this play out in the past year. Prominent case where you had redacted minutes of attorney advice. There was no other discussion in the minutes. That led to inferences or potential inferences at the motion to dismiss that was resolved against the board members. I find that troublesome and challenging for advising boards. Sometimes you have to have privileged communications that might have to be redacted, and it shouldn't lead to necessarily an adverse inference to directors at the motion to dismiss stage. I would think you would need something on top of that. But, I do agree on the principle, though, that well-drafted minutes are usually the first line of defense when representing boards, when advising boards. You need that record to be set up the right way. Turning back to the issue of Tornetta, I'll throw one last comment out there. Just something for the group to consider. The issues on materiality in that case went to the director approval, the director independence, meetings with the compensation committee. But going back to the money in the company, the issue in the case was a $650 billion increase in market cap gets $55 billion of compensation. How many investors would gladly take that deal any day of the week?
So the case that Rick was referring to, the board minutes with the inference, is one of my cases. And
There's a presumption that any
so
Delaware case.
the presumption is if I bring a case, it's good. And look, I think you have to distinguish between different kinds of cases. And this was what was referred to earlier as a Caremark case, an oversight claim. And obviously, I have seen the board minutes since. I cannot really reveal what they say. But what I can tell you is that we settled the case for $123 million and corporate governance improvements. And so all I can say is, I understand that everybody plays a role here. And as you are deciding where to incorporate, everybody plays a role here. And part of the role that we all play is advocate for our positions and then come to an independent judiciary that comes in on a fact-specific independent inquiry to what we hopefully believe in the long run as the right outcome. Will there be individual cases that people disagree with? Of course there's going to be individual cases. Look, two cases that we didn't talk about I had before one of the judges who was just here, okay, where there was, in my view, outrageous misconduct by directors. And I mean abusive, asinine misconduct. And in both cases, the judges said, yeah, but I don't see damages, I don't see harm. And so am I upset about those cases? Yeah, I'm upset, okay? But I move on, right? This is part of the system that we have. Sometimes you win, sometimes you lose, but we hope that overall we come to the right decision as we move collectively forward. And I honestly believe, if you believe that directors should act in good faith, Delaware is the place to be because they will be protected, and if they are not acting in good faith, somebody like me will come along and try to do something about it.
But are you drawing a caricature of other jurisdictions? Because I don't know a lot about Nevada, but presumably you also have to act in good faith
No,
there.
actually, there is no entire fairness in Nevada. There is no heightened scrutiny in Nevada. There is absolutely, from my perspective, no check on director self-interested conduct. So no, it's not a correction.
But I thought you can't get exculpated for loyalty breaches if you act in bad faith in Nevada.
Yeah, but the way that the courts have drawn bad faith is so restrictive that, I bring no cases. Maybe that's a solace to you guys, and you should incorporate in Nevada. I do not do cases in Nevada.
We've come to the last paragraph or two. What's missing, Rick? Anything else you want to toss in our memo? And then, Ed, I'll ask you the same question to give us the last word.
Well, it's not necessarily a point for the memo, but I think it's a point for all of us. Competition's a good thing. And we have had a Delaware dominance for a long time, and I think we've all appreciated the Delaware dominance for many years. But it's also good to have some competition. And it's somewhat refreshing to see, even if we maybe disagree with some of the jurisdictions and see the faults with going to those other jurisdictions, seeing companies have to wrestle with this question and presenting and keeping everyone honest in this discussion, because that's what competition does for us.
Completely agree. And the competition is not just the 50 states. We have clients who have gone to Cayman and other jurisdictions in order to short circuit this, because they think that MOLIS will, they don't need to worry about it. They don't need to worry about some of the controlling stockholder baggage, for lack of a better term, et cetera. But competition absolutely is wonderful, and this is a discussion and it's an evolution. It's not a binary switch.
Elena, you gave us a great framework for the memo, and the three of you filled it in nicely with your help as well. Let's thank them all.
Thank you.